Well, thank you, Brenda, and good morning, everybody, and welcome to the Law Forum, where the SLL is bringing the law to you. This is the second of 6 sessions that we are having. I'll remind you that next week, Judge Carrie Morgan of the Social Security Administration is going to be here. You probably didn't know it, but the Social Security Administration does have judges, and they decide Social Security disputes. You'll hear about that. And Brenda, who's just made the announcements here, was actually a disability reviewer for the Social Security Administration. And come on in, ladies, and we're going to have her make a few comments about that as well. The name of our speaker this morning is, I'm certain, known to almost everybody in this room, and if it's not, we're going to fix that for you in very short order. My mic need to go up. Everybody hear me? Yeah, okay. First of all, because his father was the beloved president of Western Kentucky University for many years and helped usher Western into the modern university that we know it to be now. And if you were a student or a faculty member there, you could not help but see his name on one of the buildings. But our speaker today is also very well known in the legal community in his own right. He's been a fixture here in the Warren County legal scene for many years. He has been on the bench for
18 years.
18 years. He is highly regarded in the profession not only for his knowledge of the law, but also for his razor-sharp wit. He's just a lot of fun to be around, too. And if we have anything to do with it this morning, we're going to have some fun. So please join me in welcoming Justice Kelly Thompson of the Kentucky Supreme Court. Well, I have special permission to call you Kelly, so I'm going to call you Kelly.
That's correct. Everybody here can call me Kelly.
All right. Thank you for that. And good morning, and again, thank you for coming. When we met last week to talk about what we were going to discuss this morning, one of the questions that I asked you was this, and I want to start out with it. I asked you to go back to the day that you graduated from law school, and commencement was over with, and it was UK law?
Yes.
Yes, and it would have been at Memorial Hall is where we had our commencement. Probably was, but in any event, commencement's over and you're leaving. Did you have any notion at that time you would someday sit on the Kentucky Supreme Court?
No, I knew I was ambitious. My parents, I knew I was going to go to med school or law school, one or the other. And when my fraternity left me in a cabin all night and I got a 0 on a calculus exam, I decided it'd be law instead of medicine because it was going to really hurt my medical admission. When I left law school, I got a job at the highway department. It was on the bulletin board, and I entered into the patronage system, so to speak. It was just unbelievable. I went to a job where my secretary couldn't type. She was a political appointee. She came in at 9:30 in the morning. We were supposed to be at work at 8. And she would do her makeup till lunch. And so I had no one to help me. And every decision was made by whether you were rich or poor, a Democrat or a Republican. I mean, it was back in 1972, it was very political. And I got very jaundiced at the political system, and thank goodness Chief Justice Palmore called me up and said, "You applied for a job here at that time, it was the Court of Appeals." And he said, "We couldn't get you last year, you applied too late, but if you want to come this year." So thank God it pulled me out of that bureaucracy of the government, and I ended up at the Court of Appeals that now is our Supreme Court. It was the highest court, the only appellate court at that time. And I was lucky, I got there in '73, and they were just beginning to work on the new judicial article. Before that time, the status of our court system was kind of iffy. It was not a separate branch of government as we do in the federal Constitution. It was, we weren't sure what powers we had, whether we were under the yoke of the legislature or worried about the governor. But over in the Court of Appeals, I never heard any judge arguing a case talk about politics or money. Never heard it at all. Never it was a whole different system. They decided the cases based on the merits and the justice and the facts of the case, and it wasn't involved with patronage. So it was a breath of fresh air, and I decided that's when the law became my mistress. Is when I decided that this is where I want to be. This is a good system, and it is a good system. When up where I am now, I can't imagine a better system of law. After your divorce is final in Kentucky, you're guaranteed a right of one appeal by our new Constitution, which was voted on by the voters in '75, effective '76. And you're guaranteed the right of one appeal. And we reversed the legislature that took that right away that just this recent session in one type of case. But anyway, after that, you get to ask for a second appeal. Same thing with the United States Supreme Court. You hear about a writ of certiorari in the Supreme Court of the United States. With us, it's a petition for discretionary review. We get to take the cases we want from the Court of Appeals. When we see an injustice or we see a piece of the law that's not being applied right, we'll take that case. There's also some matter of right cases. That means you get to automatically come to the Supreme Court. And the new Constitution, back then, sentences in 1975, a 20-year sentence was a long sentence in the penitentiary. Now they give them out all the time because the legislature goes in and enhances penalties to crimes, creates new crimes. Every time they meet, they get to go, we're tough on crime. And all they're doing is filling up our pens. We have the highest incarceration rate per capita, more than any country in this world, in Kentucky. We have more people incarcerated than any country in this world. And in 2013, they with a very respected leader, a commission was formed to reform our laws and to eliminate some of this incarceration. And it was a great advance. Before that, if you were charged with possession of a joint, you had to be arrested, taken to jail, post bond, lose your job, all those things. With that stroke of a broad change in our laws, they made it a citation where they wrote you, but it never would have passed by itself. It passed in bulk. 2013, our incarceration rate dropped from about 19,000 down to about 14,000 after that. Then it started creeping back up, and now we're around 30,000 and 29,000. It's just something else. But anyway, I've talked too long. Ask me another question.
Well, you know, and I shall. That brings up an interesting thing because I was on the Probation and Parole Commission in the first Governor Beshear's administration, and all of these lengthy sentences that they were handing out, courtesy of the legislature, come with a cost because you have an aging prison population who needs medical care. And the medical care budget alone for the prison population, at least 20 years ago, was $500 million a year. And so one of our tasks was to get some parole-friendly nominees or parole officers in place to start letting people out. It was just too expensive to keep them for what really we see now as relatively minor infractions. So let's go back to early on in your career. And of course, I've known you for a very long time and have got to observe you both up close and from a distance. One of the remarkable things about Kelly is the number of trials he has taken, jury trials to verdict, which is well over 500. And I can tell you that's unmatched by few, it's matched by few, if any, lawyers here in the state. That's a lot of cases to try to a verdict in front of a jury. And I think that that really makes you unique among the appellate judiciary because you do have that trial experience, and it's very broad. It's not just criminal cases, it's civil cases. So what I'd like to hear from you about is just kind of take us from early in your career on forward.
Okay, after I got to the Court of Appeals, we were working on the new constitutional amendment. And it was already in progress when I got there. Now, I'd had about 50 jury trials with the Highway Department condemning land. It was boring. If I lost, the poor old farmer got more money. I didn't feel bad. It was just the government giving out money, fair money, for the land we were taking for highways. And so I realized I hadn't learned anything in law school. I mean, I was just a baby out there trying to learn law. And so when I got up there, I was very aware of what they were saying. I understood what they were arguing because I'd been down in the trial level. And I listened and listened and listened, and that's where I learned my law. And we had a organization named the American Judiciary Society, and they were out of Chicago. They're still there, and they helped us pass this judicial amendment. And they did polling, and the judges wanted to have appointed judges. The judges on the court at that time wanted to have appointed judges instead of elected, because the elected judges, you have to go get money. You have to run against now dark money. And they wanted that, and they also thought the grand jury process was worthless because it's just a mandatory stage in the proceedings that's under the control of the Commonwealth Attorney. It's become a routine step. And they wanted to eliminate the grand jury. They wanted to go straight from arrest to indictment with what they call an information instead of the grand jury. Well, the American Judiciary Society did a poll and said you'll never pass this amendment if you take away elected judges, and you'll never pass this amendment if you do away with the grand jury process. So we put it back into the amendment. The rough thing about this amendment was that before that time, the district courts, as we know them today, of all the misdemeanors, which are your lower civil claims and anything less than a year in jail, all of those courts were controlled by the fiscal court. The county judge was your judge. Most cases, he wasn't a lawyer. He had never been to law school. Your county attorney was your prosecutor. Your county clerk was the clerk. And each county, this was a source of great power. So the county judges did not want to give up their name judge, for one thing. And we had to keep them as judge executives in the new amendment to at least give them the name judge. But they were getting the court taken away from them, which was a great vote getting power. Plus all of the revenue from the fines, the forfeitures, went to the county government. Also, the cost of incarceration of prisoners, which is still this way, was borne by the county government. And the county judge didn't want to fill up his jail because it was going to cost him money, so everybody got off in district court. Plus, it was very political, so if you knew the judge, you'd get it fixed. Then they said the perception of the court system, everybody goes to the lower court first. That's when they first see the court system, and they decide it's crooked because everything was getting fixed by the county judge and the county attorney. I'd go over to see Henry Potter. He was the county attorney. I'd never see the ticket again. It'd just go away. It's the same way with Basil Griffin, his judge. I went up to Campbellsville and tried a trial, and the judge was an insurance agent. He was the county judge, and he told me, he said, I've never been in a jury trial before. You're going to have to tell me what to do. And so anyway, we had a slogan, eliminate cash register justice, because all of the district court was oriented toward giving the money to the county, make it raising the revenue, speed traps, that kind of thing. And we were saying, we'll make it a statewide office. The fines and forfeitures will go into the general fund, not into the county government. But unforeseen circumstances, the county government still pays for everything else that they used to pay for. They didn't get that out. Anyway, it was a great improvement in our court system, and I got to be right there in the planning. And at the Court of Appeals then, you had a mandatory 1 year as a clerk, and then you had to leave. And I didn't want to leave. I loved the place. So I decided to run against Martha Lane Collins for clerk of the Court of Appeals in 1975. I got out of the court. They gave me my retirement money, which was about $5,000, a lot of money to me back then. And I drove around, and I drove about 40,000 miles around the state. I came in a close second, but I didn't win. I had 3 other men. Martha Lane would go around saying, "I'm one woman running against 4 men." And she was a sweetie. I got to know her real well, and I got to know her husband, Bill, real well, because we'd go to all the same campaign stops. We'd be there. It'd be like we were the only 2 that went to everywhere Julian Carroll went. He was the governor. Anyway, let's ask another question.
Well, let's go back to a bit more about your career. You're back in Warren County. I know that one of the things that you did so effectively but kept you so busy was that you were the public defender here for a long time, but also had a private practice. So tell us about that.
Well, I come back to, I lose to Martha Lane. I get some job offers, but I was too arrogant. I thought they weren't big enough. You know, big law firms in Louisville would offer me $12,000 a year. I said, I want 18. I mean, that's what the salaries were back then. So I came back here and I had nothing to do, so I opened my own law office. Well, first I retired for about 5 months. My parents were in Florida. They had a house, so I had a house to live in. Had a couple of clients that paid me some money. And I thought, well, I'll just stay here and retire. Well, that got old. Now, I'll never retire because I did then. It was so boring. It was, I'd get up in the morning and don't know what to do. I'd sleep late as I could. I'd go run the streets looking for whatever. And anyway, while I'm here, I want to introduce my wife, Melody, in the back of the room, and my mother-in-law, Deborah Lofson, the best mother-in-law you've ever seen. They're monitoring the class. Well, anyway, after I thought, well, I'll open an office. And I opened a little office, and a few people came in, and I had some income. And it was down on the corner of 11th and College, across from where Big B Cleaners was, next to the courthouse. Anyway, after that, the public defender contract came up. Gordon Johnson was our public defender. Back then, the public defenders was a very loose-knit organization. They had about an office of 4 people in Frankfurt, and they would give out money to take the poor people's cases in the county. And before that, everybody that got appointed had to do it for free. You know, it was just part of, so if you were a young lawyer, they would appoint you to all these cases, murder, death penalty, everything, and you'd have to work for free. Well, now they gave me $30,000 to do all of the criminals in Warren County, and that paid all of my overhead. Everything else I made was profit. And I hired a couple other lawyers to work for me. I had 4 lawyers eventually subbing out. I was giving them $10,000 a year. I was getting 45 or something. But anyway, the beauty of that was I could still take civil cases. And I could take criminal cases outside of Warren County. Nobody was following any of these rules. I could have taken them in Warren County, but I decided not to. Anyway, as public defender, I represented everybody that couldn't afford a lawyer, and that was a massive caseload, but most of them were real simple. It took about 20 minutes. You get to know, it's like a doctor. You just know how to fix the case, how to dispose of it, what will happen. And if they want to talk to you too long, you say, I'm not talking to you, you were going on to, and get this case over with. And on a little side trip, I would have people that would come in charged with possession of marijuana, and with Henry Potter, that was a $100 fine every time. I mean, it was always across the board, period. And their grandmother would come in and say, I want him to be a confidential informant and get out of this. And I say, well, he's going to get a $100 fine. Well, I want him to go to jail for a week and punish him for this conduct. It's a $100 fine. Anyway, I got to take civil cases and sue people. And my theory was that all of these poor people are drunk a lot, and they'll have a lot of wrecks, and there'll be a lot of work for me. But they would go hire, the TV advertisers for the wreck when they came back, for their accident.
Well, good. And so tell us some more at this point about your trial experience and the types of cases you've tried over the years.
Well, I got to pick my trials. As public defender, I had other lawyers that I could give the junk to. So I picked winners. I went 6 years with not losing a case one time. That was in the mid-'80s. But anyway, I got to pick the cases I wanted. I had 6 death penalty cases. My first death penalty case was in 1976, I think, 77. And I talked to Judge Allender was the judge, and I said, Judge Allender, you know, if you make a mistake in a guy unknowingly receiving stolen property, it takes this much error to reverse you. But if you make a mistake in a death penalty case, it takes that much error to reverse you. And so he believed that. I don't know if it's true or not, but anyway, I made a motion to sequester the jury. And so we went through the jury panel, and back then the jury, I knew everybody on the jury. The juries were picked by law by 3 men, not women, sober and true, to go through the voting list every January and pick out names to put into the pills, to put into the drum, for us to have our jury trials for the rest year. Maybe 1,000, 2,000 names in this drum, but they're all from the Rotary, they were all from the Chamber of Commerce, they were all from Western, they were all from the hospital. I knew every one of them. So anyway, I got this death penalty case, and I'd remembered in law school that they had this thing called systematic exclusion of a member of the jury of a portion of a jury panel. And I filed this motion, and I subpoenaed in these last 5 years of 3 commissioners. I had 15 witnesses come in, and I said, and I'd never seen a doctor. I'd had 150 jury trials and never seen a doctor on a jury. So I said, you never picked doctors, did you? And they said, oh, we picked doctors, but we didn't pick lawyers. 6 of them said they didn't pick lawyers. And so had the trial. Judge sequestered the witnesses, took them out to the Holodome, which was our best hotel in town on the bypass, and gave them an unlimited expense account at the room service. First night out, they got drunk. I came in the next day to start trial, no jury. Judge Allender took us in there and said, well, I've got something to report to you. Last night, the jury spent $241 on room service, all on alcohol. I can't have a trial today because that'll be a reversible error if we go there. And I'm going to put them on a 2-drink maximum from now on. So a couple of nights later, I'm walking into Dodd's liquor store on Fairview, and here comes the whole jury panel with 2 bailiffs walking into the liquor store to get their liquor. There were divorces, there were marriages. That was it was about a 3-week trial. It was something. And so anyway, the jury found him guilty. It was circumstantial evidence, but he was 18. It looked like he was guilty of me, but they gave him life. And back then, we didn't have life without parole. Life was 8 years. So it wasn't such a bad sentence for shooting a woman in her face. I mean, anyway, I had to appeal. He had life. So I appealed, and I go up in the Supreme, and we now have a Supreme Court because our Constitution came into effect in between there. And I go up to appeal, and lo and behold, they loved that argument of systematic exclusion, and they said the case was reversed because a big segment of the population, the lawyers, were not included in the jury panels in that drum of things. Well, I didn't want an appeal. I didn't want to win because if he went back, he could get the death penalty again. So I had to go back up there and argue that they shouldn't let me win my appeal. And they changed their decision on that. And the legislature the next year changed the law and made a voting list from a random computer selection. Jury list would come from a random computer selection of voting lists. 4 years later, they amended that law and said, we'll now homogenize driver's license and voting lists together and do random computer selection. And after that, we would get these sheets of computer paper printed off with all these randomly selected people off those. And all of a sudden, the jury panels changed. I didn't know everybody on the jury. I only knew 2 or 3 people on the jury. The jury was coming from Corvette plant, was coming from the factories, was coming from the places that you didn't usually see people. And so anyway, our verdicts started changing. The civil verdicts for being hit by someone or being injured by someone's negligence, they increased. The not guilty verdicts increased because we had a different jury panel, not a law and order. Charlie Hardcastle is the former mayor of Bowling Green, and he was on one of my juries, and he still remembers this trial that day. This guy was not guilty. He was accused of kidnapping a woman and keeping her out at a motel on the Louisville Road and abusing her and then taking her home to her boyfriend. When she got home, the boyfriend said, "Where were y'all last night?" And she said, "I got kidnapped." Well, I had witnesses. She said she had never seen the guy, and I had witnesses that they were flirting with each other at the laundromat for months, and that all these witnesses at the laundromat saw her voluntarily get in the car with him. I had the Indian guy that owned the hotel, whose room was right next to him, that never heard anything while they were in the room all night. And he saw her several times, and she never said she was kidnapped. So it was going to be a winner. I was convinced of it. Well, the jury went out, and they stayed out, and they stayed out, and they stayed out. And I thought, well, what on earth is going on here? Well, they came back, and they gave him 90 days for disorderly conduct. And so later, Lee Huddleston called me and said, "I saw where Charlie Hardcastle was on your jury. How do you recommend it?" I said, "Well, not guilty, I guess. It was 90 days for disorderly conduct. He could have gotten life." So Lee put him on the jury. So I saw Charlie. I said, "Charlie, I recommended you to Lee Huddleston to be on the jury." He said, "Yeah, I got in there and we all took a vote. It was secret ballot in writing. We all took a vote." See, the jury gets to decide how they want to decide their case once they get in there. Most times they don't do that. But for his case, they took a ballot. It was 11 for not guilty and Charlie for guilty. And he said, "It took me 5 hours to get that 90 days. and he got it by saying that somebody will get sued for this if we don't give him something." Anyway, I'm off on another tangent.
Well, I told you all we were going to bring the law to you, and here you go, okay? This is a lot of fun. We're going to change gears a little bit, and we're going to fast forward to you taking the bench. Now, how did things change for you once you became a judge?
All right, I got elected to the Court of Appeals. I had run twice. I ran in '83. I told you I wanted to go back there. I ran in '83 against a guy named John Miller, who was also a novice, and he beat me out of Owensboro. And then I ran in 2003 against John Minton and beat him in, we had 14 counties. I won 13 counties, but he just stomped me in Warren County, so he won that one. And so I'd lost twice, and then I did win on the third attempt in 2005. And I go up to the Court of Appeals, and first thing, I'm walking in my office, and I said to myself, thank God I never have to go to family court again. Family court is the most emotionally exhausting place you've ever seen. The clients are all wired up, and they osmosis into their lawyers, and then the lawyers get all excited. And everybody totally believes in their side of the case, and if you're a good lawyer, you totally believe in your client, and you believe in it, and it's just exhausting, and it takes a lot of time, and there's a lot of arbitrariness to you as a lawyer because there's no jury box in a family courtroom. I love juries. You talk to 12 people like you all, and you'll get the right verdict. Well, anyway, I walked in there, and it was quite a change in pace. I'd been a trial lawyer all my life. I'd been in courtrooms, and I still have dreams to this day that I'm in a trial. And I've met somebody that suffered a tremendous injustice in my dream, and I go to court, and we're getting to it, and I'm in front of the jury, and then I go, you're a judge. They're going to kick you out of being a judge for being in this trial. And then I wake up. This goes on over and over. I mean, that's how much I love trials, jury trials. Juries are just wonderful things.
But you're not an advocate anymore.
No, you lose your passion.
You decide the cases, so tell us about that.
Well, you lose your passion when you become a judge. After you get experienced, you see so many situations, so many points of view, so many sides to so many stories, and you get kind of numb to the level of inhumanity that happens, and we get the worst of it. I mean, we get these appeals telling us these horrible, horrible facts, sex abuse and just wanton, extreme sociopathic murder. And so you get to see all this, and I used to be a pretty partisan person. Now I'm nonpartisan as I can be. I see both sides and look for injustice and look for how to improve the future of law. And going to the Supreme Court was just an amazing experience. I'd been on the Court of Appeals for 14 years. I'd written 1,000 written opinions that are in, when you see those law books on law and order, those were my works published in there. And I guess that's my legacy, is my published opinions. I don't know who will ever read them, but anyway, I went to the Supreme Court. I didn't have a clue how it was going to be, except from being in it. I was up there maybe 15 times before I got there as a practitioner. And anyway, there's a lot of unwritten rules. It took me about 4 or 5 months to learn some of the unwritten rules, and they still try to pull that on me and say, this is an unwritten rule. Oh, no, I'm not doing that anymore. Anyway, there's not many written rules. There's traditions and policies, and, like the first opinion I wrote, I thought one of the judges that I used to work with on the Court of Appeal did an outstanding job in the Court of Appeals. So I said, Judge so-and-so in the Court of Appeals wrote a good opinion. They said, nope, you don't say that. You don't say their names, you just say the Court of Appeals. The reason is because if you're going to say the judge did wrong, you're not going to say his name. So don't say he did it right, I guess. That's the reasoning. But anyway, I got up there, I didn't know anything, and they said, well, you got to have an investiture. And I said, I don't want an investiture. How would I get anybody in Warren County to come up here for this? And I don't want to do it. And they said, you got to have it. I said, okay, we'll schedule it. And so anyway, we threw it together at the last minute. Carrie Platt, my videographer back there, she was up there, and she put it on YouTube for me. She's going to put this on YouTube. But anyway, the investiture was like Queen for a Day. It used to be a TV show when I was growing up, or Who Wants to Be a Millionaire? How all your life, I was honored. It was just quite a privilege. It was quite a ceremony, and I was amazed, and I was humbled, and I was embarrassed by it. But it was quite a show, and I kept adding to it. I had from the American Legion, I knew a guy that was the head of the ROTC at Greenwood, and he brought his unit up, and they came in with the colors, and they had to keep their flags from hitting the chandeliers in the courtroom. It was quite an experience, and a good friend of mine, Terry Cornell, I stuck him in at the last minute to sing the national anthem. And then I asked Jeff Taylor, a judge on the Court of Appeals, to say a minute, and he talked for 12 or 15. And then I asked Larry Thompson on the Court of Appeals, and Larry's wife's name's Kelly. And so I was on the Court of Appeals as Kelly Thompson. Larry Thompson's on the Court of Appeals, his wife's name's Kelly. I call up the first time, the secretary tells us, the judge, Kelly's on the phone, and he goes, hi, honey, and I answer the phone. Anyway, let me tell you a story about one of my trials back right after I became public defender. I was assigned, as a public defender, I was assigned a boy who was from Louisville, and he was a freshman at Western, and he was on the football team. And the facts are that at Royal Carriage whatever that, Carriage Hill Apartments down next to Hilligan's on College Street. All right. The alley back there at the back goes right up, there's a little parking area right up next to the building. It was a nice fall night. Everybody had their windows open that looked over the alley towards Center Street. And I heard a car alarm go off, and 4 or 5, 6 people stick their head out the window, and they see this guy running down the alley, carrying things out of the broken window in the car, and carrying some things from the car, and running off. And he was a big black man, and he was wearing a red beanie, and a white shirt, and red shorts, and white tennis shoes. And so they're all out in the alley, and the police are taking a report, and they're giving him a report, and here comes a black man walking up the alley wearing that exact outfit. And they all go, "That's him!" So they arrest him, and they can't find anything he stole. They searched every place for 4 blocks around looking for whatever he took out of the car. I can't remember what it was, jam box maybe. And so anyway, we have a trial. And a lot of times the Commonwealth offered me 3 years probated. But I knew the jury would give him 1 year if they found him guilty, because he was a clean-cut young man who had no prior record, who was a good worker, good, articulate, polite. He would have done well. But anyway, the thing was, he told me, he said, "Well, I'm a freshman on the football team, and we're a pledge class, so to speak, and we had a party going on the corner of College and 12th in a building, in a house there. And there were 30 of us there, and we were all wearing the same outfits. So I said, find me 4 guys on your team that were there, and I'll put a subpoena on them. I had to subpoena them, so that way the Commonwealth can't say, you're his friend and you came to help him. No, I'm here under subpoena. So I subpoenaed them to come and wear that outfit in the subpoena. And I didn't tell the Commonwealth attorney anything, because we're in an adversary proceeding. So they finished their proof on the second day of trial at lunch, and I come in at 1 o'clock, and I bring in those 4 guys, and I have 5 guys standing in the front of the room, all dressed the same, all big black men. And the jury's looking at them, and they can't figure out who's who. And anyway, had all those eyewitnesses, and the jury found my client not guilty. Shows you about eyewitnesses.
So let's go to your current office, and you all have decided to grant discretionary review. What's the process for getting the case ready for you all, and then the decision-making process that culminates in a written opinion?
Well, there's all these unwritten rules again, and I'm just still learning them. But first, after you lose in the Court of Appeals, after you've had your 1 appeal, you get to ask us for discretionary review. We have 3 staff attorneys that read the records and make us recommendations. Off of that recommendation, then I'll go search the record myself if I see what I think is an injustice or a flaw in the proceedings. We then have a debate in our conference room, and this is the same conference room, exactly the same books on the shelves that were there when I was there in 1973 and 74. Everything's exactly the same.
And let me interrupt you. There's 7 justices.
7 justices. The Constitution gives us each 1 vote. We're all, back when we were doing the constitutional amendment, they decided that if we didn't make them into geographic districts, Louisville would have all 7 judges because of their population. And so we made 7 equal population districts across the state. And each one of them has a Supreme Court justice and 2 Court of Appeals judges. And the geographic, that makes all of us from a different part of the state, all of us with a different background in law. Some were specializing in civil work for big law firms. Some were family court people. Every judge comes from a different background. Every judge, then we listen to it. Now, at discretionary review, we decide we're going to take this as an oral argument or we're going to take it as a non-oral argument. We usually publish both those. Sometimes we don't publish one of them, but every now and then. But anyway, once we decide non-oral, I'll write an opinion on it and it won't go to oral argument. Oral arguments, we have about 6 a month, 5 a month, and we listen to the arguments argue, and we've read the briefs. We go into the room and we haven't talked to each other about, well, some of the judges talk. They try to swing votes, and I refuse to get into palace intrigue. I just don't want I want everything to be said in the room or put in writing and published to everybody at the same time. I don't talk about cases without the other participants. But anyway, we all argue the case. It's common sense. Nobody's talking about money. Nobody's talking about politics. We make a decision, and we all chip in our 2 cents worth, and what we come out with is an opinion that's better than what any one of us could have done on our own, because it's been nibbled at and chewed at and criticized and improved. And we all edit each other's opinions to try to improve the way it's worded. It's just a marvelous process of justice. It really is. It's just the most perfect system I can imagine. And you know, back in the old, well, hundreds of years ago, thousands of years ago, they said the village elders would run the village, would make the wise men, experienced men, only men, remember, no women. Anyway, they were the council, and they're still doing it over on the other side of the world, where the old men run the show. But anyway, some kids came in to do as part of the presentation, and they watched us during an oral argument. And after we left, the bailiff said, one of them asked, why are all those people so old? But anyway, it's a great system of justice.
Well, we have an innovation in the court coming the first of the year, don't we?
Which is that?
We have a new Chief Justice.
Oh, a new Chief Justice. Yeah, that's not much of an innovation. That's just a changing of the guard.
But
Larry Van Meter was elected judge when John Minton retired. I didn't have anything to do with that election. He became a judge 2 months before I went up there. And just like that time, this year, Larry Van Meter is retiring after his 2 years. He's been a judge all his life. He's paying the government to work for us. I mean, he could retire at more money than he's making, I believe. Anyway, and he doesn't need it. So anyway, he's retiring, and we elected a new judge, Deborah Lambert. She'll be the first woman judge, Chief Justice in the history of the court. Remember, there were no women on the court when I was there in 73, 74. It was all men. Times are changing. Now there's more women judges than there are men in this whole system. And we will have probably 4 women and 3 men on our court next time. The favorite is a woman to replace Larry Van Meter. So anyway, Deborah Lambert grew up in central Kentucky, and around, I don't know, she lives in Somerset now, and that's not far from where she grew up. She was a family court judge. Her first husband was Joe Lambert, who happened to be a Chief Justice of the Supreme Court. But they got a divorce many years ago, and she's now married to another Joe, a really good guy. Both of them are really good guys. Anyway, she's really good. She's she's very concerned with mental health. She's taken the lead of the Mental Health Commission, getting mental health courts searching for people who are really mentally ill, who have been ensnared in the criminal system. And back when I was public defender, I did all of the mental illness cases. And back then, we would have maybe three a week. And a typical case would be a woman is babbling. It doesn't matter.
We're getting ready to go to break anyway, but let me just shut that off. We'll come back to that.
A typical case would be a woman, I remember, was found on State Street babbling, and the police are called, and she's incoherent, and they charge her with disorderly conduct. causing a disturbance in public. It's like the minimum charge. But as soon as she gets to the jail, they call life skills, and they sent down their psychologist, Larry Breen. And he will evaluate them and decide if they needed to have a commitment instead of jail. And this woman, I remember, had 20 bus tickets in her purse. The way we treated mental illness back then, if you found her, you'd give her a bus ticket to Louisville. She'd get off this bus in Louisville and be their problem. And her bus tickets went all the way to Florida, Atlanta, just all the way around. Now, if you were mentally ill, like we did with her, you went to Western State Hospital. We only had 2 hospitals for mental illness, Eastern and Western. And Western State's in Hopkinsville, and they were masters of medicine, just unbelievable. People would be babbling and couldn't control themselves. They'd go over to Western State, they'd get them on their medicine. The problem with mental illness is a lot of it can be cured with medicine, but people don't want to take their medicine when they get cured. Then they get back to the problem again. And there's no way to forcibly watch them take their medicine. They've now gone to 30-day shots instead of taking a pill every day, which is better. But anyway, they were good. They would get you out of there and back home by the end of the week. And you would be okay, normal, functioning, and being a productive member of society. The ones they couldn't cure, you would go up in floors. I think it was like a 5 or 7 floor facility. And the ones on the very top floor had been there for a year. They couldn't figure out what to do with them. And the place was packed all the time. These people are coming in like an assembly line from all over the state, or all over half the state, and they're pumping them in and out, keeping a few. And it was quite a system. Well, anyway, Debbie Lambert has really taken that by the horns. She's formed a mental health court. She's formed a mental health commission. That's her pet project, and it's doing God's work. So I expect her to keep doing that and go forward. But the Chief Justice has just got 1 vote like the rest of us. The Chief Justice is the administrator. He does the administration. And every month we spend 4 or 5 hours talking about administration. I didn't know the Supreme Court was going to be so top-heavy with administration. We authorize what the Bar Association does, what the Kentucky Bar Foundation does, what the IOLTA Foundation does, what the Pretrial Services does. We administer all of the court system and their budget through the administrative offices of courts. If we're taking a break, let's quit here.
Great time to take a break, thank you. Marion is our bailiff today, and she's called us back to order, okay? All right, so I want to touch briefly on some of the other innovations during your career that you've seen in the legal system. We've talked about the 1976 judicial reforms, which were massive. You heard Kelly talk about John Palmore several times, probably the towering figure in the history of jurisprudence in Kentucky. We've touched on 1 or 2 other things. We now have a female Chief Justice, and a majority of the court are going to be women now, which is amazing.
Not yet. The election's in November.
Oh, the election's in November, okay, yeah. But if all things pan out, we'll have a majority of women justices. We have 2 other innovations I'd like for you to talk about, which are videos and pretrial services.
All right. After John Palmore was Chief Justice of the Supreme Court, our next Chief Justice was named Bob Stevens. Bob Stevens came over to the court after I had gotten there and before I left in end of 73. He was the county judge in Fayette County, as I remember. Very experienced guy. He later became, after he retired from the court, the head of the Justice Cabinet, administrating that part of our state government for 4 years. But he came up, or he got us cameras in the courtroom. And every courtroom has a camera there, has 5 cameras. They're all set aiming at a spot. So if you're sitting in the witness stand, there's a camera aiming at you. If you're standing at the podium as a lawyer, there's a camera aiming at that spot. There's no camera aimed at the jury ever. The camera is over the jury, aimed out into the courtroom, but you cannot see the jury's face in any video. The judge has a switch up here, and the camera in the back of the courtroom is aimed at him. So if the lawyers come up to the bench to talk, he can push the switch, that camera locks on him and the lawyers, and it mutes the sound from the rest of the courtroom with white noise. All of this cost, at the time in 1988, we started putting them into Warren County. And there had only been 2 other counties with them at that time. Now every courtroom in the state has them. They got them by the mid-90s. And there was a lot of opposition to this because we had court reporters before that. And the court reporters made money. They got a small salary, but they got their money from transcribing what they heard, what they recorded with their stenographs. And the problem was, if you had a trial and and the court reporters were very busy. There was court going on and they had to be in court, so they could only type at night. And it might take a year to get the transcript of a trial. Meanwhile, you're sitting in jail for a year waiting for your appeal, and they can't even start the appeal till we have the transcript from the trial. These were automatic. A lot of people didn't know this, but the clerk would give me videotapes of today's testimony when I'd go home at night, and I could go back there. I remember finding Peanuts Gaines had said about 8 different ways that the people entered a house, and I spliced them all into one tape and showed it to them during the closing arguments. Peanuts would go, well, I went in first, and then I went upstairs. And then the next time he says, well, Joe went in first, and then I went upstairs. And then I stayed out on the porch because he testified all these times about a month apart, during the preliminary hearing in district court, during the suppression hearing in circuit court. And anyway, I showed all that to the jury, and the jury found that guy not guilty. But anyway, we have videotapes. And the video record, everybody said, well, how are you going to use that? How can a judge go through a record? Well, that's not our job. It's the job of the 2 lawyers. They have to cite every video that's being taken, has the tape, time, and second that it's being taken. So you have to say, the judge said this, videotape 8/17/92 at 11:47:41. You got to put exactly where you found it in the record. Now, nobody ever questions anymore what is said, because if they do, it better be there when you get in there. And if you put it in your brief, it better be right, that you're quoting accurately from the video. So it's the job of the videos. So now, when a trial's over, you can take it up immediately. Meanwhile, thousands, hundreds, millions of dollars that would have been paid to court reporters by litigants or by the government is now not paid. We don't pay a penny. We pay $15 for the videotape of the trial instead of $2,000 for the transcript, and wait a year. And we have instant access. Now, before the videos, judges were autocrats. They were the kings of their courtroom, and it's amazing. One time, Bill Rudloff and I almost got into a fight during a deposition. I mean, we were standing over the table screaming at each other. And these young lawyers were in the room looking at us. And so anyway, I thought, boy, wait till, and I was the one wrong. And I thought, boy, when that transcript comes out from that court reporter, I'm going to be fried. Well, when I got the transcript, it said, Mr. Rudloff, you're not going to leave the room. Mr. Thompson, yes, I am. And I'm taking my client with me. And it was like that. And it was so peaceful compared to what really happened. We were screaming at the top of our lungs at each other. And it just doesn't come across. So the video gives a much more accurate description of what's going on in the courtroom. And the judges who we had a judge up in Grayson County, which I wouldn't go back there. After a while, you had to give me a lot of money to take a case in that county, because when we went in there, he made the lawyers line up at attention in a semicircle around his bench. He made us stand there while we argued our motions. And one time, once again, Bill Rudolph was back in the back of the room. He didn't have a motion to the very end. He sat there reading his newspaper, and he held him in contempt for reading his newspaper too loud. And anyway, those judges, I just never went to those counties again. But when the videos came out and what their conduct would show is if they were totally inappropriate in court. And it modified, we could take it right up. This judge yelled and screamed at me in front of the jury. He shouldn't have done that. And they'll look at it and say, he shouldn't have done that. He should have sent the jury out to the jury room and then yelled and screamed at you, not in front of them. And so it modified the conduct of the judges. It eliminated a lot of money we were spending. The court reporters fought it tooth and nail, but we just did it. They didn't have much say-so in it. And eventually every court in our state has been on videos since the mid-90s. And that's the only record we take. It's cheap, it's fast, it's accurate. It's just a marvelous innovation. And we were the only state in the country to do it. And now there's maybe 5 states that do it. And they come here all the time to study us and go back to implement this in their states because it's such a marvelous system. Now back in 1972, Julian Carroll had been elected lieutenant governor, and he was from Paducah. He was an outstanding man. He was just a wonderful man. And he did great things for Kentucky. When he ran his campaign, and I was running against Martha Collins, all we did was follow Julian Carroll. Where he was having a rally, we would go and there'd be 2,000, 3,000, 4,000 people there rallying for his election. And Wendell Ford was the governor in 1970. And in 72, he appointed himself to the Senate and he left. Julian Carroll became governor. Julian Carroll was a lawyer from Paducah who had had a lot of conflicts with bail bondsmen, especially a company called Johnson Bonding Company. And Johnson Bonding Company had bail bondsmen in many cities in Kentucky, and all they did was sign their name. When I first started practicing law, you'd go to the jail to see a client, and there would be bondsmen. There'd be 3 bondsmen in the jail all the time waiting for someone to get arrested. They would go up to them and say, do you have a car? Do you have a TV? Do you have cash? I'll get you out. They would take the people's cars and TVs to sign their name to authorize you to be released. If you didn't come back to court, they sent a goon after you to kidnap you and bring you back to court if you were across the state line. And they were authorized to do that. It was totally a bad system. So when he outlawed bail bondsmen from Kentucky, and we had to have a system. And that, once again, was when I was there. And so Judge Palmore had a study done of what do they do in other states. Well, everybody used bail bondsmen. In all the states except for New York City, they didn't use the bail bondsmen. They used pretrial release. And what we've realized was that, well, first, the New York study said that we've handled over 100,000 people. We've released them from jail on their own signature. We've released them from jail if they have a job, if they have a house, and if they have a phone number. And we can verify that. We have found out that all but one of them came back to court on his own without any problems. And what we figured out was that if a guy has got no record and he's charged with shoplifting a $2,000 diamond ring, that's a felony. He's going to get a felony conviction unless you can sweet talk the Commonwealth into recommending an amendment down. And you know he's going to get out on probation. He's not going to sit in jail because he has no record. It's a minor property crime. And why were we holding him in jail at the cost to the state? for 2 months before we let them out of jail, when we knew right on the first day what was going to happen. They were going to get out of jail. They weren't going to be incarcerated. Why were we punishing people before they were found guilty? So we started this system, and everybody pulled their hair out and said, this isn't going to work. Everybody's going to run off. Well, everybody came. Everybody came back to court. And that started our pretrial services agency, which has grown and grown and grown, and is now another big bureaucracy in our court system, and its job is to analyze. And they've taken away some of the discretion from our judges. Now you look at California and other places, and they've kind of adopted our system, but they made it more liberal. We leave it up to the judge in his discretion to decide whether to let you out. The pretrial makes the recommendation. And we are starting some automatic releases without the judge, and some of the judges aren't happy about that. But you hear these horror stories about people going in and just checking themselves back out and committing another crime. Well, that really doesn't happen in Kentucky. One of the rules is if you've violated a previous bond release condition, you're not eligible for another release unless there's a full hearing on it, on why you violated your first one. So it's not like what you read, the horror stories in California. Our bond system's a lot better. A big example that hurt us was where the young man up in Louisville went into the mayor's campaign office and shot 5 shots at him and missed him from right here. And they put him in the jail, and the judge came in front of him and he gave him a $100,000 cash bond. Now that is a big cash bond. If you'd had a bondsman, that would be $1 million bond, and the bondsman would have kept the $100,000 for his profit. But that's a big bond. But this guy was the head of an activist group in Louisville, and they had the money, and they posted the $100,000 bond, and everybody went, well, so the feds stepped in and charged him. Talk about going out of the frying pan into the fire. When he went to the feds, he got really hurt. But he got out for a few days before the feds stepped in and arrested him. And that gave us, but anyway, pretrial is now an established way. That's the way we do it in Kentucky. We were the first ones there, first state again, back in the old days. And when I go up to our court now, I try to say this is the way we should be. We should come up with all these new, bold ideas. But I'm beating my head in the wall so far, but I'm going to keep trying.
What is the best career advice you ever got?
I'd never considered going to the University of Kentucky Law School. Never even thought about it. I applied to Chicago, to Virginia, and to Yale. My granddad graduated from Yale in 1909. So I guess that was a legacy at Yale. And then we had to pay money to keep, after they accepted you, you had to pay money to keep your place in line, and I just couldn't make up my mind. And Doug Keene, who is a tremendously wild character from Scottsville, Kentucky, who was county attorney in Scottsville, a practicing lawyer, friends of my family, came into my house many times with his kids. I was friends with his kids, and he was Keene Hall up at Western. He was on the Board of Regents, and I saw him up at the old football stadium, and I said, Mr. Keene, I just can't make up my mind where to go to law school. I've been accepted to these 3 schools, and I cannot make up my mind, and I've been putting it off so long, and I got to go to one of them next week. And he said, well, where are you going to live? And I said, I'm going to live right here in Bowling Green. I love Bowling Green. We went out west, and I came back here, and I decided this is the most beautiful place I ever want to live. And he said, well, if you're going to live here, you need to go to the University of Kentucky. I said, what? He said, yeah, I went to the University of Mississippi. I came up here, didn't know a lawyer in this state. He said, you go to the University of Kentucky, spend 3 years, you get out, you're going to know a lot of the lawyers, and it's going to help you. And I said, okay, well. So W.L. Matthews, who used to be the president of the Bowling Green Business College before it burned down in '64 or something like that, he was the dean at the University of Kentucky School of Law. And I looked up his number. I called directory assistants and got his phone number and called him at night at his home about 8:30, and I said, Dean Matthews, I'd like to go to the University of Kentucky. He said, well, we started last week. And he said, what was your LSAT? And I said, I made the highest score ever in the history of Western. And I don't remember what the numbers were then, but it was true that I'd made the highest score in the history of Western. He said, what were your grades? I told him. He said, well, come on up tomorrow. And I went up and I started school. And that was the best career advice I ever gotten, except for the admissions committee at the University of Kentucky were a bunch of my teachers. And they saw me drop in there out of the sky the day after school had started, and they thought this was a political shenanigan, and I got punished by those teachers pretty bad. But the career advice was good. That got me to UK, and that's why I'm still here.
Dean Matthews was my first-year property law.
Yeah, that's boring.
Well, property law isn't the most exciting gig going around, but he actually was a very good lecturer. So we got about 15 minutes left, and we're going to switch into, we've been having a lot of fun, but we're getting ready to have even more fun. Tell us, if you would, about the ROTC building at U of K.
All right, well, I was kind of a semi-hippie, wearing bell-bottom pants, but I was really a political conservative at the time. I was for the Vietnam War because that's the way I'd been raised, to be a patriot. And they were having the march about the Vietnam War, and Kent State had just happened. And so I heard there was going to be a protest over at the ROTC building, and this is about noon. My girlfriend and I walk over there, and we start watching. And there was a crowd of about a couple thousand people outside of the ROTC building. And it was an old structure next to the student center up there, between the student center and the law school, and it had a big field in front of it up to the street on Limestone or whatever that street is. And anyway, the long-haired radical hippies took over the building. They went in, nobody was there. And they started throwing furniture, and they broke out the windows, and there was about 10 windows in the front of the building, and there was a guy in each window giving a speech. And they were all yelling over each other. You couldn't hear any of them. And this went on all day, and no police, nobody. They were just throwing stuff out of the building. They figured they would wear them out. Louis Nunn was the governor, and Louis Nunn called up the state police. Every state policeman in the state went to Frankfurt, and they massed there and drove to Lexington in a convoy and came over, and it was about 7:30 at night. And I mean, I thought somebody was going to die for sure during this thing. It was real confrontational. And so anyway, the state police, first the hippies are all going, we're never going to give up this building. We'll keep it for the end of time. Well, they put a couple of those dogs through the back door, and man, they were jumping out the windows. Everybody was leaving that building. So then, after they jumped out of the windows and the dogs are in there, they come around, the police come marching around the building, no guns, just batons, wearing helmets and body armor, and they're walking around the building in single file, and they hug in the building, and they go all the way around. And then they take their batons and they start pushing the crowd away from the building. And they get out about 15 feet from the building and they stop. And the crowd keeps lunging at them, and they lunge back, and this goes on for hours. Boom, boom, the crowd, it's like, ugh. The whole crowd, the whole audience. Now, really, there's 2,000 people there. There's only 100 activists, and the rest of us are watching the show, you know, but it looks to the police like there's 2,000 rioters out there. And they're going back and forth, and it's escalating, and I'm saying, somebody's going to die. Well, there was an ROTC annex over on the other side of the student center that was an old barn, really. It was wooden. And somebody set fire to that, and they probably saved some lives. Because when that fire went up, we were looking over the student center, the whole crowd, and you could see the flames coming up over the student center, and everybody's yelling, the student center's on fire. And we go around the student center, and it's this barn, and the barn is next to a girls' dorm, and the flames from the barn are going into the windows of the girls' dorm, and they've evacuated the girls' dorm. and the firemen come, and the hippies all go around there and going, burn, baby, burn. And it was quite an experience. I got home about midnight. I'd gotten in a fight with a guy, yelling, burn, baby, burn. And I never wore the pants I wore again. My girlfriend had sewed me some bell bottoms made out of yellow, big fat bell bottoms. I never wore them again because I didn't want them to see me.
So, we have some funny stories on each other.
Yeah. You gonna flash up your...
Let me get a graphic up here.
What year was that?
That was 1970, I think.
There's a video.
Kent State?
No.
Well,
Yep, there's a video. Of you, the
fire?
fire.
I didn't know that.
So you need to look it up.
It was 1970, would that be?
May of 1970.
Okay, yeah.
See yourself in yellow bell bottoms. You know?
That's what I was thinking.
Oh, the bottoms of them were that wide.
So this is kind of a joke. I always get a kick out of getting documents in, and I'll have a blank page, and someone has put in there, this page is left intentionally blank. And that's just to get us going. So tell us, Judge, about this one.
All right, we had some people. Scott Crocker and Dick Downey were former editors of the Kentucky Colonel, the student newspaper. And they were now lawyers in Warren County, and we started a little newspaper called the Bar Tab. And 11 months of the year, it was mostly news. I told true funny stories in a column, and it was the only funny part. On the April issue was called the April Fool's issue, and everything was false in the whole paper, and it was humorous, and it had some really good humor. It would, you know, like I remember the firm of Bell, Orr, Ayers, and Moore. Well, we had this guy calling Bell, Orr, Ayers, and Moore and said, could I speak to Mr. Bell? Well, he's dead. Could I speak to Mr. Ayers? He's ill and retired. Can I speak to Mr. Moore? Well, he's dead. You know, on and on, because they got all Harlan, all these guys were dead on the names. So anyway, this one, somebody drew this of Mike.
So this is 1993, and I'm a brand new lawyer here in Bowling Green, and I think I'd done some Yellow Pages advertising. And so the perpetrator of this will remain nameless. And as you might imagine, lawyers are a little inhibited in speaking about people who wear robes on this sort of thing. But this was the sort of fun that they had, and my motto, according to them, was "We draw first blood." And my office was in the lobby of the Greenview Hospital. And so, since I'm somewhat constrained in what I can say about the folks who drafted this thing up, I decided to go deep into our local bar association archives and see what I could find out about our guest today. And I came across this. This is from deep in the Bar Association archives. Inside this issue, Kelly Thompson retained to defend LA police officers claims they were on Prozac. Kelly Thompson seeks new trial for Mike Tyson, claims he was on Prozac. Kelly Thompson's tape recorder seized at federal building, claims it was on Prozac. Kelly Thompson sells rights to Prozac defense to Eli Lilly, which made Prozac. It was such a successful defense, Eli Lilly bought it from him for a reported $3.5 million. Now, did they really seize your tape recorder at the federal building?
Yeah, my tape recorder was seized at the federal building. I had it on. Tape recording something, and the federal judge said I couldn't do that, that only the official court reporter could record the proceedings. And he kept my tape recorder.
Yeah, they don't have much of a sense of humor over at the federal building, has been my experience.
Oh, I remember a woman came in, I had several women come in, and they'd had guns in their purses. Wouldn't even remember they had them. And they'd go through the metal detector. Oh, I forgot my gun. Well, they'd take the gun. None of them got punished because they were all elderly, like me now, yes. But anyway, yeah, the feds don't have much sense of humor.
Yeah, I can remember going into the federal building on Broadway in downtown Louisville, and I was chatting up with one of the security bailiffs, and they made 400 arrests a month then of people bringing weapons in probably just forgetful, but I mean, guns, knives, you name it, trying to walk in there with it. I mean, they put the cuffs on you, and they had cells there in the courthouse building. So we have time for a few questions. Is that okay?
I got one thing. I got to tell a funny
Okay.
story. This is one of the funniest stories I think there is. My job, Judge Charles Reynolds, Mike Reynolds' father, was on the Court of Appeals, and he went to the Supreme Court. So I've kind of followed him. I was on the court under the same seat. And when Charles Reynolds died, there was a big, huge funeral at St. Joseph's Catholic Church. And we're all down there, and at that time, Joanne Coleman's the district judge. Jim Gildersleeve, who now works out at J.C. Kirby, is the court administrator. And I are sitting in this seat with Steve Wilson, who was a prosecutor then. And Jim turned around to Steve and said, "Steve, I'm not a Catholic, but I'd like to go through the communion line. Is there some sign you give the priest to tell him that you are not a Catholic?" Steve said, "Yeah, there is, Jim. It's this." So Jim goes up through the communion line, and the priest is holding it, and Jim does this. Well, the priest admonishes Jim, and he comes back to the pew, and his face is so red, and he's about to explode. "Steve, why did you do that to me?" And Joanne Coleman said, "Steve, you'll go to hell for that." Anyway, that's the way we goofed on each other all the time. But Steve was the worst. All right.
So we've got time, a couple of minutes for some questions. Yes, ma'am.
So, I don't know if this is appropriate for you to answer this or not, but I have a question about legal language. Like, I was looking at the proposed Amendment 1. Now, it states who cannot vote in the state of Kentucky. And the first is felons. Okay, I think we all know that. And then there's some other things. And then the number 3 thing is idiots and the insane. Now, who pulled that language out of their ear? Okay, I know insanity.
Are you talking about in the amendment itself?
It's actually in the amendment.
Well, the legislature passes the amendment
yeah,
to put on the ballot, and they write the language of the amendment. And you will find that when you get to any amendment, you don't understand what it's asking for. And a lot of times, the way it reads is the direct opposite of what it is.
Well, they might end up disqualifying themselves.
I guess what I'm asking.
There's no automatic.
Idiot and insane.
They're probably in a
legal language, or is it something somebody pulled out of their butt?
I have no idea. But I'll tell you for sure that the amendments are drafted by non-lawyers in the legislature who have a political agenda. They want that amendment on there for some reason, and they word it in the most confusing way that anybody could word them. Most of the time when they come up, it's impossible to figure out what you're voting on unless you've heard about it before. But I don't know about I'm sure there's a procedure for keeping the insane from voting, but it would be a specific procedure on an individual basis.
Well, and that's my thing. Who decides who's an idiot and who's insane?
Used to be a jury, it'd be a competency jury that kind of.
Okay.
Oh, and I got a real fast story about competency. I was appointed to this woman, and she was out at Royal Arms apartment, and her son was in the CIA, and he had come to Bowling Green to visit her, and they went out to Red Lobster, and she had a fainting spell, and he went down and said, "She's incompetent, and I want to take over her rights and control her money and control her business." And I thought, I'm going to defend this one. So I go out to Royal Arms, and this lady is dressed perfectly. Her apartment is perfect. We go in. I spend 4 hours with her. She was so charming. I had the most wonderful time. She served me cookies and tea. We watched baseball. We watched Wheel of Fortune. And I said, "Ma'am, do you know your son is trying to take over your rights?" "Oh, he wouldn't do that." I said, "Well, he is, and we're going to beat that tomorrow at the jury trial. I promise you, he's not going to take over your rights." Well, the next day I wake up and I'm going to go kick some butt. I go in there and I sit down next to her, and she looks at me and says, "Who are you?" Anyway, that's a competency trial. The jury gets to decide.
Last question, please. Yes, Larry?
Judge Thompson, I just thought I'd share with you, I'm Jim Gilderslee's brother.
Yeah.
I'm looking forward to asking him about
He'll tell you the same story I told you.
Well, this has been delightful. Thank you so very much.